All rise. Please be seated. Kathy Smith and Theodore Visnor, case number 10-23064.
Good afternoon, Defense Counsel, please.
Bruce Havens, Your Honor, here on behalf of the creditor, Shelly Sweet.
Good afternoon, and ma'am, good afternoon to you.
Leslie Honig, Your Honor, on behalf of the debtors, Theodore Visnor and Kathy Smith.
Good afternoon, and folks, good afternoon to both of you.
Thank you.
Mr. Havens, this is your motion, so I'll let you proceed with it.
Thank you, Your Honor. I appreciate your calling it a motion. We took a very circuitous route getting here. It was a strange route, largely of my creation, or all of my creation, frankly. The first time I got involved in this case, Judge, was about a week prior to a closing that was scheduled on this property on the 30th. Ms. Sweet, I've known her for a long time, and she stopped in my office, and I was with a client. She gave me a file, indicated what her problem was, indicated that the folks had moved out. I grabbed her file. I said, let me take a look at it. We'll figure out what we can do to get your property sold. I looked at the file. When I looked through the file, I found that there had been an action filed in the Isabella County court system to evict the tenant from the property after the bankruptcy had been, or excuse me, there was nothing in there that indicated when it had been filed at that point in time. Subsequently, I found that the notice to quit had been served well before the bankruptcy had been filed, but it was just a couple of days ago that I found out that the actual complaint was filed in the district court after the bankruptcy had been started. In any event, there was the file that I received had a copy of a judgment of eviction. It had been entered after the bankruptcy had been filed. Ms. Sweet had told me that Ms. Honig had been there and was representing the debtors but didn't make an appearance in the case. My assumption was at that point in time, because it was my understanding the property was vacant, that she didn't have any objection to the court continuing to hear the matter. In any event, I chose to file this action the way I did because had I followed any other method, it would have required notice and a 14-day hearing, or at least a 14-day opportunity to object, in light of the fact that there was a different address on the petition. The party had testified at the 341 hearing that they didn't live there. The statement of intention on the paperwork showed no intention regarding the property. I thought the safe course of action, in order to try to expedite things, because I didn't believe that the debtor had any interest in the property, particularly in light of the realtor's letter. I guess, Judge, I'm relying on the fact that you've looked at the paperwork. I know you're very good at that.
I have looked at the paperwork, Mr. Havens, and so far everything that I've seen is supported by what you're telling the court in terms of the timing.
All right, well, then let me shorten things up, Your Honor. I filed a notice basically as a prophylactic method of giving the parties notice. There was an objection filed late on Friday, which I did not get and did not tell my client about. She took possession of the property. There was stuff there. At some point in time during the week, she called me and the police were there, and I found out that the debtor had filed a motion to set us, in district court, had filed a motion to set aside the judgment of possession. I told the officer on the phone, well, there's a hearing apparently scheduled on that tomorrow. Why don't you just tell everybody to go home and go to court tomorrow? He said no, that She had a valid order of possession, so I told Shelly to give the keys to her and walk away, and she did. And I expected the hearing to be held tomorrow. Well, then somebody, I don't know if it was Ms. Honig or whether it was Shelly's attorney, but somebody notified the district court that a bankruptcy had been filed. Now, I know this is redundant information to the district court. So Shelly went over that day to court. She came back to my office and she said, the court just adjourned the hearing and they're waiting for the paperwork to be supplied to close the case. So I hand-filled out an administrative closure order, wondering why nobody had ever thought about this before, gave it to Shelly, she took it over and filed it, and that's why we're in your court. I think they waived jurisdiction, but frankly, all the stuff that happened in district court is irrelevant, basically. What we basically have here is we have an issue that she wants to stay in place longer to remove the stuff. We've been now a week short of 2 months. My understanding is she drives by the property 2 times a day, wants to take her kids to school and wants to come back from school. At this point in time, my client's paying $50 a day to keep somebody held up in a hotel, and there has not been, and admittedly in their pleadings, there's not been any adequate protection paid. And the case law is clear on this issue that when adequate protection isn't being paid and there isn't a long-term lease that has any benefit to the estate, that the stay shouldn't continue. At this point in time, Judge, the trustee has abandoned all interest in all of the assets, both the personal property, any interest in the lease, any interest in anything that was cited in the bankruptcy paperwork. They have, the trustee has filed a report regarding other assets that the trustee intends to look into, but not these assets. So, from my perspective, based on the report that the trustee filed, the trustee's abandoned his interest in the property. And I guess the question I'd like to ask at this point in time is, does the debtor concede that Shelly Sweet is the owner of the real estate?
Mr. Havens, are you looking at the trustee filed a report, it looks like on